Hello, everyone. Welcome to our YouTube channel. I'm Jeff Hampton with the Fulgham Law Firm, and today I wanted to introduce you to a topic that has brought up quite frequently at our law firm, and that's the issue of harassment. How to beat a harassment charge in Texas. Now, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's jump right into this. Now, maybe you or someone you know, maybe a loved one is facing a harassment charge, and it's a little confusing. You see the charge of harassment, and what does it even mean? I mean, how many of us have been harassed by people calling online? You know, how many of us have been harassed by people wanting to sell us things through media and different things like that? But the law is very specific. There's a difference between a harassment in a civil court and actual criminal harassment. There are specific elements of the crime that must be met and must be proven beyond a reasonable doubt by the state of Texas. So now I'm going to give you the definition. If you want to go research this, you can look it up under the Texas Penal Code, Section 4207. And it states that an individual commits the offense of harassment when he or she acts with intent to harass, embarrass, torment, alarm, abuse, or annoy someone else. Now, that is a super broad definition. I mean, that could be, and it also seems to be very subjective in the eyes of the beholder as to whether someone thinks they're being annoyed or alarmed based upon someone's conduct. So let's talk about some very specific acts that have been deemed to be potentially harassment under the criminal laws of Texas. Number one would be obscene communication. So the act of initiating communication, whether electronically, in writing, or by telephone, and making a proposal, suggestion, comment, or request that is obscene. That's number one. Number two, threatening communication. The act of threatening in a way that causes another person to be reasonably alarmed that acts of bodily injury or felonies will be committed against the person's family or household, or against the person's property. Okay. Number three, false reporting. The act of knowingly conveying a false report that someone else has suffered serious bodily injury or death in a way that causes the recipient or the reporter of it to be reasonably alarmed. Then we get to harassment by telephone. Okay. The act of causing a telephone to ring repeatedly, making anonymous phone calls, or intentionally failing to hang up with the intent to harass, embarrass, torment, alarm, abuse, or annoy someone else under reasonable expectation. It can also involve knowingly permitting another person to use the phone under the original person's control to commit an offense of harassment through the use of a telephone. It's real simple. You could call someone 70,000 times, call them 1,000,000 times, and the intent to do so is to annoy them or alarm them, okay? Then we're going to get to a section here that I'm going to park out on for a couple of minutes and talk a little bit more in detail, and that's electronic harassment. All right? In the past, the act of sending repeated electronic communications in a way that would cause reasonable likelihood that another person would feel harassed, embarrassed, tormented, alarmed, abused, annoyed, or offended, that could constitute harassment. But within the last few years, there's actually been some court rulings in the state of Texas that even though the Texas Court of Criminal Appeals has not definitively ruled on this, the current state of the law as it stands right now is that these electronic communications do not constitute harassment. Okay. Now, what do I mean by that? Well, let's say someone sends you a repeated number of Facebook messages, or someone texts you an unreasonable amount of times, okay? Or maybe an email. What about email correspondence? Someone emails you 1,000 times in a very short period of time. Now, in the past, that could be seen, if it was done with the intent to annoy or alarm, that could be seen as harassment. No longer, okay? And here's why. Courts have ruled that that is a protected form of free speech. It's a form of speech that is permitted. If you don't want to receive that information from someone, you can block them. You can block them on their email. You can block them on your text messages, and you can unfriend them through Facebook. There's all these other options that you can do that. And so I say that to say this: there are many clients that we've represented, and it's astounding to me years later that there are detectives who still have no idea that this law is in place. They are literally, I mean, even recently at our law firm, we've had clients arrested for harassment based solely upon electronic communication. And if that maybe that's your situation, the detectives many times don't really care what the law is as it relates to that if they hear it from a defense attorney, okay? But the law is what the law is. So that is no longer deemed under current law as harassment, okay? Now, what is the punishment for harassment charges in Texas? Well, according to Texas Penal Code, harassment is a Class B misdemeanor, punishable by up to 180 days in the Tarrant County Jail or any county jail in Texas, and up to a $2,000 fine. Now, if you've had previous harassment charges, that could increase the range of punishment up to a year in county jail and up to a $4,000 fine. But generally, harassment is a misdemeanor charge in Texas. Now, you say, well, if it's a misdemeanor, why does it matter? Well, because I'm guessing you would prefer not to have, or your loved one would prefer not to have an arrest record for harassment on your permanent criminal record. So it's very important that these charges, that you have an attorney that aggressively fights these type of charges and make sure that you have the opportunity to not have this as a permanent stain on your criminal record. Now, I appreciate you listening to our YouTube channel today and listening to this particular situation or this particular crime. Maybe you're facing this today. If you are, we want to offer you a free consultation through the Fulgham Law Firm. Don't hesitate to contact our office at the Fulgham Law Firm at 817-877-3030. We'd be happy to speak with you, go over your set of facts and maybe your unique set of circumstances. And I promised you also, if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. I encourage you to click the link below. We'll be happy to send that over to you. And thanks again for joining us on our YouTube channel today. We look forward to seeing you on our next video.